Can a landlord or tenant carte blanche terminate a commercial real estate lease? That's what we're going to talk about today in the Commercial Real Estate Talk podcast. Thanks for tuning in. I'm your host, George Morales of Blue Box Real Estate. If you haven't already on our Commercial Real Estate Talk podcast, please hit that subscribe and give us a thumbs up and share us with others. So there's a famous case that just came out. The Supreme Court, this is from CoStar, lets a $10 a year lease with Sears stand at the Mall of the Americas in Minnesota. I don't know if it is already or still, but it used to be the largest mall in the United States. Imagine, Sears has 160,000 square feet. It's a lease signed in 1991. They're only paying $10 a year for this lease. You heard me right, $10 a year for 160,000 feet. Apparently, according to the article, it was a 100-year lease that signed in 91, so they're not even halfway through this lease, and they probably have options to boot. Well, you could imagine this was Simon Mall. Why would Simon Property Group, why would they sign a $10 a year lease? Well, the mall opened up with Nordstrom, Macy's, Bloomingdale's, and Sears. Remember, Sears is the loss leader. They're the traffic driver. So you put in a Sears back in the early 90s, and then others are going to want to come and feed off their traffic. So you need that Sears, you need that anchor tenant in order to fill up the rest of the mall. And when you're overbuilding, and they built the largest mall in the U.S., you needed that. What's 160,000 square feet? That's maybe 5% of the mall. I don't know what it is exactly. Don't quote me. So you can give that space away to fill up the other 95. That was the idea, and that's why they gave super cheap, maybe sometimes rent-free leases back then. But what happens now, fast forward the tape, we're in a different environment. I'm sure Mall of America would like to do some different developments, perhaps collect more rent than $10 on 160,000 feet, and they've been trying to cancel this lease. Sears also filed for Chapter 11 bankruptcy back in 2018. That kind of got muddy. The lawsuits happened, and it went back and forth, according to the article. Well, the Supreme Court refused to hear the case, which means they're allowing the lower court standing to take precedent, which is a lease is a lease. It's a commercial lease. It's binding. Sears has every right to be there throughout the term of the lease plus options and pay $10 a year. Imagine, this is probably the most profitable Sears, if it's still open, in the United States, because they're at 0 basis point, no rent, or $10 a rent. I mean, probably the employee of the month gets to pay the rent for that year. But what this has sparked is an interesting conversation about a lease agreement, because listen, I get this question often from clients. Sometimes they sign the lease. I did a 10-year lease with a Fortune 500 company back in the early 2000s on a new development in Coral Gables, 22,000 square feet. I kid you not, no less than 90 days after the ink dried, the tenant came to us, and at that point I was representing the developer, the landlord, and said, "We need to terminate this lease. We made a mistake." And we said, "Sorry, we have a lease. We're moving forward with the space plans that were approved in the lease. We're going to build it out, and we're going to start charging you rent." It's exactly what we did. That tenant then offered us several times different mechanisms to terminate the lease. We said no. We have a bankable lease, a financeable lease with a Fortune 500 company. They weren't going anywhere. They weren't declaring bankruptcy. As soon as the space was built out, they had to pay rent. They hired a broker and tried to sublease their space, which they did. And finally, actually, I even think years later, when the subtenant moved out, they decided to reopen their Miami office, and all was well and good. But a lease is a lease. So when a client asks me before, can I get out of this lease? I have to honestly tell them yes or no. There's certain mechanisms that you can ask for built in ahead of time that perhaps you can. Let's talk about that. First, let's talk from the tenant perspective. How can a tenant cancel the lease? What if this was in reverse? Sears was paying $1,000 per square foot, or $1 million a month in rent for this space, and they wanted to terminate it. How can the tenant terminate their lease? Well, there's 5 ways. One, the easiest is to negotiate an early termination clause. And again, small tenants, you're probably not going to go there. Focus on shorter terms, 1, 2, 3, 4-year terms. Larger tenants signing 10 years, 20 years, perhaps this is something that can be put on the table in some cases. When you're developing new, shell, build-to-suits, no, because the landlord's going to need the 10-year term to finance the deal, and it won't happen as a termination. But Termination clause allows a tenant to end the lease early. There's going to be different stipulations. There could be notice provisions. Usually it's at least 6 months ahead of time, maybe as long as a year. Perhaps there's going to be a penalty. You have to pay 4 months rent and forfeit your deposit. So all that is going to be negotiated up front in the lease, early termination clause. 2, assignment or subletting. I've got to get out of the space. I don't have a mechanism to terminate, where you can always hire a broker like Blue Box Real Estate, and we'll bring your space to market. See if we can find another tenant to come in and take your space and make those rental payments. You have to be prepared to take a haircut, usually 10, 15, I've seen it as high as 25%. But collecting 75% of the rent from another tenant is better than paying 100% to the landlord in a space that you just don't need. So early termination clause, assignment. How about a buyout option? You can go to your landlord and ask for a buyout option. I owe 2 years of rent, and the landlord says, okay, listen, it's a good market. Pay me 50 cents on the dollar, and I'll let you out. It's still a big check you're going to have to cut, but it's better than paying for the next 2 years worth of rent. Pay 1 year in advance and get out. Buyout option. There are certain markets, like in retail, that have go dark clauses that you can negotiate. So let's say you're a small retailer, you're a hair salon, and Publix is the anchor tenant. And the reason you are leasing that space and overpaying for that space next to Publix is because you want that Publix traffic. And you know, as long as Publix is there, you're going to be very successful. Well, what happens if Publix closes for whatever reason? I just had a Publix in my neighborhood close for about a year for redevelopment. Well, that's going to destroy your business. And so you might be able to negotiate what's called a go dark clause. If that main anchor tenant goes dark, I can terminate my lease at my option. For whatever reason, they might go dark for a renovation. They might go dark because they moved out. Or perhaps you approach the landlord if you have a go dark clause and you dramatically cut your rent until that time when another anchor tenant comes in. But that's another option to get out. The other is force majeure. Now, this is baked in most leases. Don't bank on this one. Let's just say there's a fire or an unforeseen event, an act of God, a hurricane, and the property is damaged beyond repair, or it's going to take too long to repair. You may have, after a certain amount of time, an escape clause to get out of that lease. Again, if you're a small tenant, ignore that. Large tenants know about this, and they're going to negotiate this. So those are the 5 ways from the tenant perspective that a lease can be terminated. Early termination clause, assignment or subletting, buyout option, go dark clauses, or a force majeure. Now, look, I'm going to probably summarize this in a 1-minute short, but this is going to be the more expanded version. Now, what about from the landlord perspective? I know most of our audience is most likely tenants, but you should know what the landlord has at their disposal to terminate your lease. Some of this is already in there. And you need to know about it. Okay, number 1, termination for breach. This is an obvious one. And frankly, that could have been one in the tenant side, though it's very difficult to terminate a lease from a tenant perspective for breach of contract by a landlord. But let's just say landlord can terminate your lease if you fail to pay rent, right? There's usually a grace period of 5 days, and then there's a notice, and then there's going to the courts and hiring attorneys and going to the sheriff. And I mean, it could take 60 days, 45 days if you're not paying rent, if a landlord's really on the ball to get you out of that space and recapture. So if you breach, it could be a breach of use. Like I said, you were signed a lease and you were supposed to be a medical office tenant and you just changed your mind and decided to go into co-working. The landlord might be able to terminate your lease because you changed your use. That's a breach of the lease as well. So not just financial, but it could be of use. It could be parking violation. The ratio's 2 per 1,000, and you're loading up, you're running a sweatshop, and you have 3,000 people here. Again, so that's a little more difficult to terminate. But a breach of contract, the landlord can terminate. That's number 1. Number 2, there could be a demolition or redevelopment clause in your lease. That would be spelled out in there. I've got a client, and she's been in a property for many, many years, when the landlord has a demo clause. If they ever decide to redevelop the entire office building and terminate all the leases with certain notice, they can terminate your lease to move forward on that redevelopment. Well, why would a developer want this? Well, think about it. If you have an older B or C building in a great location, it's probably not the highest and best use Perhaps one day someone will want to buy that building, terminate all the leases, and redevelop it as resi or high-end office or something of a larger scale in an assemblage. And so this gives the landlord the flexibility of selling the project or redeveloping it one day for its highest and best use. So look out for that in your lease. Landlord can terminate for breach. That's standard, but there might be a redevelopment or demo clause. How about condemnation or casualty clause? So this is the reverse that we talked about in the tenant. Listen, if the property is condemned, okay, they've failed their 40-year certification, or there's all kinds of issues with the building that's unsafe, and you come in, the city might come in and condemn the building. There might be a casualty, again, hurricane, massive loss, beyond repair. The landlord's saying, listen, it's going to cost way too much to build this building back. It's just not worth it. We'd rather demo it and start a new development. They can terminate your lease. Those are all baked in there. How about mutual termination agreements? This is where both parties get together and negotiate. For example, what if your space is very sought after by a larger tenant on that floor, but that you don't have a right to relocate? So the landlord comes to you and says, hey, we'd like to mutually terminate your lease so we can make room for this larger tenant. And you start negotiating. You say, hey, look, I owe him $500,000 of rent. Yeah, let's agree on some number. In this case, perhaps the landlord pays you money in order to move, to relocate, and to have some free rent wherever else you're going. There might be a mutual termination. That's not going to be baked into the lease. Another one, fifth, non-renewal notices. Now, some leases don't offer renewal notices. So obviously, the lease is going to terminate, expire, and it's done. But sometimes at the end of a fixed term, tenants like to ask for an automatic renewal or get that renewal option. Some landlords will hesitate in giving that to smaller tenants. Larger tenants usually have this. But obviously, the end of the term is a way that the landlord can say, your lease is over, you're done. So those are 5 ways: termination for breach, demolition or casualty, condemnation or casualty, mutual termination agreements, or non-renewal notices. I think I said demolition or redevelopment clauses, I meant to say. So 5 ways a landlord can terminate your lease. Again, I'll put this in a quick short, but this will be the expanded version for learning purposes. Well, thanks for tuning in. I hope this was benefit to you and your business. And don't forget to reach us at blueboxre.com for any of your commercial real estate needs, not just reviewing these leases, trying to keep you out of trouble, but understanding the market and your space. If you're in Florida, reach out to us. Thank you. Have a good day.